the kind of strapline for Caged Prisoners is giving a voice to the voiceless. And really it's through people like David, Geoffrey, Toby and Saghir that we have the opportunity to do that. Because it's often within the legal realm that those voices are given an opportunity to finally get their moment in court, to proclaim their innocence. But as Toby's mentioned, not everybody necessarily gets that chance. And so our mission really is to try our best to look at all these various forms of counterterrorism policy and legislation and bring them together so that we understand them as a single phenomenon rather than as being disparate abuses. So if Toby just works on enforced disappearances and torture, and David, you just work on, kind of small counterterrorism policies in the UK, and we don't start making the links between how the whole machine works, we're never going to be able to actually work against it. And this is the big problem, actually, with a lot of the work that has been done by civil society, by NGOs, by lawyers, that we've taken such a client-centric focus to our work that we've forgotten the wider picture. So other manifest abuses start taking place, but because they're not as serious or not as seemingly serious, that nobody notices this entire matrix developing. But when you start linking them up, this is how it goes. Somebody like myself, Muslim man with a beard, goes to an airport trying to fly out of Heathrow, maybe to go to Pakistan. I get stopped there. I get stopped under Schedule 7 of the Terrorism Act, and they ask me questions like, what's your view on the war on terror? What's your view on jihad, on Palestine, on the war in Iraq? What are your foreign policy opinions? By the way, questions I have been asked, and plenty of Muslims in this room have been asked as well. These are the standard questions now that you receive. What's your view on democracy? So you come and you say something smart like, well, democracy, what's democracy? Only, less than 20% of your country actually votes for the government in power. Right. That doesn't sound so serious, except the PREVENT strategy sets out that criticism of democracy is extremism. That's part of the definition of extremism. And if you criticize democracy, you are an extremist according to the PREVENT strategy. Okay, so what difference does the PREVENT strategy make? You go to Pakistan, you get there, and lo and behold, the ISI are there waiting for you. They pick you up, they push you around a little bit, maybe beat you up, maybe pull out your fingernails like they did Aurangzeb Ahmed, and you go through all sorts of terrible things. But they eventually release you, and you're permitted to go back to the UK. But you get back to the UK, and all of a sudden you get arrested. Sorry, not arrested. They come to your house and they give you a piece of paper which says that you have now been put under a terrorism preventative investigative measure. Why? Because we suspect you're an extremist. What evidence do you have that I'm extremist? Sorry, it's national security, we can't tell you that. But you know and I know why that guy is under this measure now. Because the laws are so vague. The definitions are so wide. The whole system works side by side in order to what? In order to enable the situation where basically they can put the allegation of extremism or terrorism on somebody without actually any process, without them having to prove anything. Because at the very minimum, they're able to take that individual out of the equation for 2 years because he's locked away in his house. So why bother trying to investigate? Why bother trying to build a case, going to the expense of building a case against somebody when you can basically end things there? And so, this is the work that we do at Caged Prisoners. We work with the people like the lawyers here. We try and investigate these cases, try to bring them to light, and we ask you to support our work in any way you can. Basically, we want your minds, first and foremost, but if you're able to help by donating something, we'd appreciate that. There's some standing orders forms at the back. And of course, those of you on Twitter can join the conversation, #RuleOfLaw. But now I want to open the floor up to question answers. We've got a roving mic back there, so please put up your hand. And I think because of the problems that we're having with the mics, we'll just take it one question at a time. So if there's any questions, please feel free to fire them at our panel. Yes, please.
Hi, my name is Julia Senna. I'm a student at City Law School, studying for the BPTC. I really hope this question isn't inappropriate, but as at least one panelist noted, there are lots of law students in the room. And I'm just wondering today, in light of the threats to the criminal bar, in light of the cuts to legal aid, in light of the really intense competition for pupilages, you know, young law students who want to get into the field, who want to do criminal law, who want to do human rights law, I mean, what sort of practical advice would the panel have? I mean, it's not too on topic, but...
Toby?
Well, certainly not an inappropriate question and a sensible economic question. As I said, one of the main reasons why I'm fortunate to work in international work is I don't have to rely on the publicly funded criminal bar. I never saw myself doing anything other than criminal work. I think, like David, I have absolutely no interest in doing commercial work. You're entering the profession at quite possibly the worst time, unfortunately. I'm quite annoyed as well that I was called to the bar in 2000, 2001. I spent about 8 years outside the country and then came back just as things were falling apart. So I'm quite annoyed as well. But I think there are opportunities there. There are certainly opportunities in this field of work. What I would recommend, as I recommend to anyone who asks that question, is undertaking an internship or two, getting international work. Unfortunately, you have to realise, and I understand doing the BPTC is not the cheapest thing in the world to do. To then go and do unpaid work for a year before you go and do poorly paid work as part of pupillage is quite something to ask. But I can tell you, when we advertise for pupils in chambers in the international practice group at 9 Bedford Row, we receive simply hundreds of applications. And it is the masters in international law, it is the internships that set people apart from the others. I think, if it's not too condescending, if you are really determined, you will succeed. I firmly believe that. I'm probably the best example that if you do really keep at it and irritate people and keep kicking a door open, it will open eventually. So I can only empathise with you for what you're about to go through, but the training internships, I think, is probably the best way to get it. If this is the field of work you want to do, I would not recommend anyone in this room to consider a career at the criminal bar, the domestic criminal bar, as it currently stands. Time will tell whether there will be an independent bar in a year or 2 years' time, whether there will be a fusion of the profession. Nobody really knows. I can tell you that for myself, I'm also a partner in what I would call an international law firm, which is one of these new mixed practices of solicitors and barristers working together. I think that's probably the future. But the international experience is what is essential.
Can you have some more names with regards to people who have these agendas and
staring me up
could the panelists possibly elaborate on that and maybe give us some more specifics and names with regards to that?
I mean, this is not secret. You know, I mean, there are particular group of people, ideologically driven, who have openly said it. And I said, you know, just go and Google Islamophobia industry. Just go and Google Douglas Murray, neoconservatism, Henry Jackson Society. There are people there, and to be fair to them, they're open and honest about their views, and there's nothing wrong with that. As a civil liberties lawyer, I would say, look, if you want to say we want, for example, a secularized Europe, there's nothing wrong with that. That's your view. And as long as you express that fairly and openly, transparently, there's no problem with that. And I think we talk about clash of ideas, you know, the whole issue of, well, you Muslims are bringing these values, you're doing this, you're doing this. I'm thinking, well, let's have open debate. Let's go to universities. Let's go to different forums, come and debate with us, come on TV, and let the ordinary people decide. But the problem is, as Asim said, is that when you answer back, you're branded extremist. You're denied space at universities to speak. You're denied space in the media to speak. So when you're only defined as an extremist by these think tanks, you know deep down they are not interested in creating social cohesion. They're not interested in furthering the civil society in this country or the West. They are interested in their ideological hatred, which they've built up, and their prejudice, which they will not want to let go, whatever your arguments. So yeah, the people are out there. If they want to debate us, we'll anywhere, anytime, but they won't. But the only worrying thing I would say is that, and the reason why I do want to mention it, and I hope it's tweeted, it'll come out more, is that these people are not seen for what they are. They are ideologues driven by agendas like the Tea Party in America. They have particular agendas which led to the war in Iraq. And when they go to universities, when they go to the Charity Commission, when they go to the various media organizations, those organizations should be aware where they're coming from, and then hopefully allow us right to reply. Thank you.
I myself aren't a law student, but I was wondering if the panel can comment on the parallels between the case of someone like Gary McKinnon and Sheikh Abu Hamza. You both have disabilities in one form or another, but one was obviously denied the extradition, and the other one, in Abu Hamza's case, the government went ahead with the extradition.
As I recall, the McKinnon case was a case of a man who was autistic, and he had an illness. I mean, he was in the end, that's what it was that brought about the withdrawal of the extradition. In the case of Abu Hamza, of course, this whole terrorist mythology, if you like, or that all affected it, and yet, on the face of it, it looks like a straight case of discrimination on grounds of race or colour, because the young white lad, he was allowed to remain, and Abu Hamza was continually persecuted. And so it's actually quite difficult to justify the discrimination between the two. But it depends on how cynical you are, really. I mean, how you view it. That's really all I can say.
I mean, I think one of the similarities to bring out is that with Sayyid Talha Ahsan, who had Asperger's syndrome, same as Gary McKinnon, and in fact had been placed, had been assessed with as being a suicide risk, exactly the same as Gary McKinnon as well. So, as Geoffrey rightly pointed out, this was very much about race.
My name is Jamal Harwood. I'm from the Islamic political party Hizb ut-Tahrir. I have a question for Sir Geoffrey. And again, thank you to all the panelists. It's a very enlightened discussion. Let's just look forward maybe a few years, maybe not in 2, but maybe 7 or 12. I mean, if we do see a Conservative party come to power, how much of a threat is there to the Human Rights Act? I mean, there has been discussion of a British Bill of Rights. You know, what exactly is that threat? And could you maybe indulge us a little bit by presenting some of your thoughts of what that might mean compared to what we have now? Obviously, the picture painted today is actually quite negative, and I think I appreciate the fact that there are many leading lawyers, such as yourselves, actually saying that we need to, you know, put a line in the sand and stand up to this. But I do get the feeling that we are on a slippery slope in this country, very sadly. And I would just like to get your thoughts, and maybe some of the others might have a view, as to what might mean by having, let's say, a British Bill of Rights, or if we do withdraw from the Human Rights Act. Thank you.
Well, I think part of the problem in answering that question is that we don't really know what is meant by a British Bill of Rights. And there is obviously a school of thought on the right that says the Human Rights Act, the Convention, they are foreign imports. We want something which is British. Now, when you analyse that, the argument collapses, because the Human Rights Act and the Human Rights Convention are essentially British. If you want to look at the origin of the various principles, you can go back to Magna Carta. You can find them in a lot of English law. So we have this difficulty that we are perhaps I want to defend the Human Rights Act because I want those principles, those human rights principles, to be observed, protected, defended, and by law. That's what I would like to see, and I think most people here probably would agree with that. If the Human Rights Act was repealed, which the Tories are promising, the one obvious change that would take place would be that if in the courts one wished to raise a human rights issue, the UK courts would no longer formally have jurisdiction to decide it, and you might have to go to Strasbourg to argue your case, assuming we hadn't withdrawn from the European Human Rights Convention as well. So, in a sense, that's the only technical difference. Others argue that because we've had the Human Rights Act and we've had the Human Rights Convention for so long, that our domestic law has already changed sufficiently to embody the principles of human rights, and therefore that it wouldn't make a lot of difference. You'd get the judges reaching the same sorts of decisions, even though they couldn't refer directly to a Human Rights Act. So it's an uncertain position, but what we're seeing at the back of all this and what we have to worry about is not so much the legal technicalities, it's the whole drift, the whole anti-human rights basis of the opposition to it. It's the desire to get back to some or to maintain a hierarchical society based on the oppression of the poor and the enhancement of the situation of the wealthy and privileged.
Thank you. Sorry, David.
It was just really to echo that. I mean, if you have a society based on the rule of law, it's going to be the case that there'll be some times when the state loses. There are going to be some times when the stronger, more wealthy party loses. And that's obviously going to be unpopular with people in power. But really this debate about the Human Rights Act is the same debate that we had in the 1950s about whether the courts could judicially review decisions of ministers, whether actually defendants were entitled to be defended at all in the 19th century. But I really would like, if I could, just to make one point relating to the question, the first question about becoming a criminal lawyer. I'm afraid that I was the last generation to be fully funded through university and to be able to have my legal education paid through scholarships. And so perhaps I'm not the right person to ask. I know that it is harder than ever before to become a criminal barrister. I know from my own chambers we have about 400 applications for one place, and every CV looks absolutely perfect, and it's almost a lottery who we pick. But what I would say is to be patient. First of all, it doesn't matter how many human rights acts we have, if there isn't a core of people prepared to stand up and defend those human rights, then actually whatever acts of parliament we have and whatever laws we have are meaningless, and we are actually no better off than the old Soviet Union or today's Zimbabwe or Bahrain, where they have constitutions which are far more fair and open than our country, and yet everybody knows that their trial process is totally unfair. So I would say that you're needed more than ever before. I'd also say that be patient. There's no reason why somebody has to be a lawyer in their 20s. I qualified as a barrister at the age of 21, and the truth is I sat in a room for 9 years twiddling my thumbs because every client I ever might have had took one look at me and said, this guy's got a full head of hair, He's very young. He's obviously never done this trial before. I want somebody older and more experienced. So there is actually no harm in waiting until you're a bit older, getting as much experience of life as possible, and coming back. For myself, I have absolutely no doubt that there will continue to be a role, whatever it's called, for somebody who is a full-time advocate. If you are defending any serious trial, you spend every second thinking about that case. It's simply not possible to do that if you're really working part-time, if you're working in a firm, if you've got billing to do, if you've got to do other cases, if you've got to ring up somebody else. You've got to be full-time. And frankly, I cannot see that changing in the foreseeable future.
Yeah, sure, absolutely.
Can I also say that, unlike Toby, I'm very much in the market for doing a highly paid commercial case. I've always intended to do one, but for some reason there's some good case that gets in the way. I would love to. I've always taken the view that it's a lot easier and simpler and doesn't require as much intellectual involvement.
I just wanted to add to the comment about withdrawing from the Human Rights Act and the European Convention. It's quite interesting that the government would be prepared to restrict the rights of every member or every person in this country just in order to get rid of one person who actually now has voluntarily agreed to go to Jordan. So perhaps there's no longer a need to withdraw from the Human Rights Act. But the one point which is always interesting when the government talks about withdrawing from the Human Rights Act and the European Court is they seem to overlook all of the other treaties that we're parties to. So it's not just a matter of getting rid of the Human Rights Act and withdrawing from the European Convention. They will have to consider about 13 other treaties in order to do effectively what they want to do.
I'm conscious I'm rather one of the exercises, but the question I want to ask is about where a human rights NGO stands in relation to erroneous legal decisions. We've talked about the European Court of Human Rights, but we like to imagine there's like UKIP, Theresa May, and the Daily Mail on one side, and the Strasbourg judges on the other. But even as a critical friend of the European Court of Human Rights, they felled the Hillsborough families, they upheld the Turkish and French hijab bans, they legitimised supermax isolation in the case of the extraditions. And people still, campaign, the Hillsborough families campaign despite losing, and Amnesty and American Civil Liberties and many others still campaign against supermax isolation despite the European Court of Human Rights legitimising it.
Yes, that's a very good question, actually, because it does have a bearing on the need and the reasons why we have this seminar here, right at the heart of the legal profession. Because part of the thing is that this whole erosion of due process, what's happened in the war on terror, etc., these are political battles going on, these are legal battles going on. And what we felt, and I'm harsher than most people, so forgive me if I'm unfair, I feel that the majority of the legal profession has failed in trying to uphold those principles. And those battles could have been taken on much longer, much earlier, when those principles were being sort of reduced in the 90s and early 2000s. And this is why what I said when Sir Geoffrey finished, I said, look, how did we end up here? So we had to go back those 10, 15, 20 years. So really we should have drawn those red lines much earlier. And as far as the judges are concerned, whether it's the European courts or whether the English courts, people have careers. People have, they're human beings. They're susceptible to public opinion. They're susceptible to political pressure. So when David Cameron, for example, makes a speech in Munich threatening the European judges, you might say that those judges themselves thinking in a very difficult position, we may have to let this go, but we'll accept this. So they are also making unwritten, unconfirmed, sort of unnegotiated compromises with the executive. And that's what's happened, I think, is the executive's gone more and more powerful, and the judges have felt more and more pressurized. This is why we felt there was a need to start addressing the issue of rule of law, and there'll be more seminars on this. And if I may just finish, Amjad, very quickly, is why I am quite negative, and I think it goes back to what Jamal was saying earlier, what the potential trends here are. It's something that I've been quite alarmed, and I heard Gillian Slavo, who was the South African anti-apartheid campaigner in the early 2000s, when we were campaigning against the introduction of the control orders, where we were saying that the first time for centuries we have a situation now where people's liberty is going to be denied without having to go through due process of a jury trial. And then one of the compromises given by the government was, okay, we'll let judges have a discretion on this, final say on this. And what she said was, she compared the issue with the development of apartheid in South Africa. And at the time, I remember vividly what she said. She said, look, when apartheid was introduced in South Africa, the early opponents of apartheid laws were the legal profession, because they recognized all the rule of law, all the due processes, everything they learned over the years was being totally eroded for the sake of picking on one section of the community. But unfortunately, and this is what the warning I still remember, she said, look, after 10, 12 years, those same lawyers, those same judges actually became part of the machine, because it became an issue of careers, became an issue of promotions, became an issue of their incomes. So be very wary as to how much you allow the legal profession to just suddenly fit into the whole process. So yes, I think we all lawyers as well, we need to be very careful that we don't fall into that trap. Thanks.